cannabis has worked like that for them. But it's not going to do that for everybody. For some people, it just is like a magic medicine, and it can be really instant and it can be really quick. For others, it might be just a slow, relaxing or easing of pain or helping you to sleep or whatever. But after a while, and you know, we've been passionate about it for 30 odd years here in Newman. Hemp Embassy's been going for 25 years and Mardi Gras 25 years. And it's so nice that now people are listening a bit to us, because we were just nutty ratbag hippies for years. And you know, a lot of those hippie ideas like coal seam gas, solar power, stupid ideas, solar power, you know, we were nutbags. And now, so it's interesting to look at all that and how us humans resist change so much, don't we? We want to stick with our known world, and you know, steak and 3 veg, that's dinner and nothing else. So you've got to question everything nowadays, I reckon. You know, the whole environment's full of chemicals. We've poisoned our rivers and we've poisoned the earth, and it's a shocking thing, and we're going to slowly find out about that, I reckon. Anyway, a lot of you here are country people and you know about that stuff. So we've got a big program, lots of different people talking. I'll keep interrupting, Sista will keep interrupting. And there's quite a few people outside, quite a few doctors and nurses here. And if you really need to talk to someone and want to, just find me if you can't find them, and I'll line you up with someone. Because there's good experience and advice here today, and you should feel free to pick everyone's brains. Make a donation if you can, is great. And I'm just going to kick into it. Now, Steve Bolt is from Bolt and Finlay, solicitors and mediators in Lismore, and he's probably come to just about every Mardi Gras in 25 years, and been very passionate about drug law reform, written a book about cannabis law reform, and he knows probably more about the court issue of cannabis in court than anyone. So I really appreciate you coming out here today, Steve, again, and he might talk for 20 minutes or half an hour, then you ask him questions, and ask anything you like today. I want you to pick our brains. Thanks heaps for coming. I should do a welcome to country. I'm a bit cynical about, you know, everyone ramping off their welcome to countries like some road thing, but in Nimbin we love blackfellas. They cause a lot of trouble, but as total outsiders I can relate to them. I've got a lot of personal friends who are Aboriginal and part Aboriginal, and it's pretty clear to me they did a better job of looking after the place for like 100,000 years, and we've trashed it in 200. It's tragic. So appreciation of them. Here today. Thanks, Steve.
Thank you, Michael. And I'd also like to acknowledge that we're meeting on the land of the original wild people of the Bundjalung Nation and pay my respects. I'm not going to stand up or sit down, I don't know, we'll work it out, we jump up and down. Like Michael said, well, I've got about an hour, I think maybe a bit less. Like Michael, like a lot of us, I'll talk all day if you let me, so no one's going to let me. What I want to do, as Michael said, is just run through 3 or 4 main areas for maybe 20 minutes or so, and then have the rest of the time for questions. So hopefully we'll cover the main ground in some ways.
Please use this microphone.
And yes. Even people with loud voices, it's much easier if people can use the microphone to say anything make a comment or ask a question from the floor. First things first, cannabis is illegal. Everyone knows that, I suppose. Cannabis remains illegal in New South Wales and in fact in every other state of the country. There's been various announcements in recent years about medicinal cannabis being made legal. Announcements, headlines. It's kind of true, but mostly in a practical sense not true. The law that changed 2 or 3 years ago now, both state and federally, was to introduce a system of patients, sick people, being allowed to apply for a prescription and for the medical profession to prescribe cannabis. Sounds okay. The practical problem is that in the last, that was 2016, 2 years or so, as far as I know, there's around about somewhere between 500 and 1,000 people, maybe 700-800, who've managed to get through that process and actually get legal cannabis in the whole country. So it's not much of a legal solution. The process is incredibly bureaucratic. You have to, first of all, if you are a person who wants to use medicinal cannabis or cannabis for medicinal purposes, You have to find a specialist who says that you really must use cannabis, that nothing else, no other medicine will work. You have to get that specialist to write a report that goes to the Department of Health in New South Wales, the federal government agency, the TGA, the Therapeutic Goods Administration Act, have to approve it as well. If they approve it, many doctors, a lot of GPs and doctors have tried and just sort of give up. But anyway, if you get through that part of the process, then you get approval for an authorised medicinal cannabis product to be administered. At this stage, I haven't kept up with all the fine detail. As far as I know, the only approved medicinal products now have to be imported from a country where medicinal cannabis is legal. They allow you to import basically a synthetic cannabis product, Sativex, or one of those, dropidanol, one of those kind of cannabis, not really, cannabis products that kind of work, not really. So the ordinary good old-fashioned weed that people in this room might have had some experience with and might be using, the products that are made by, on a smaller scale, various oils and tinctures and so on, none of them, to my knowledge, have yet been approved, and none of those are legal. So yes, the headlines are kind of true. Cannabis is legal for some people, but a tiny fraction of the people who need to use it and of the people who need to assist people who use it to get a supply. Carers and friends and so on who need to still need to go through the black market to access those products. Second thing I want to say is a slight bit of good news if you're in a very bad news situation. There is a system in New South Wales, actually two parts. There's some leeway for the police. So although cannabis remains illegal, the police have some discretion. The first one is the bad news one. If you have a terminal illness, that is, you have 12 months or less to live in a doctor's opinion, if you've got a report that says that, there is a scheme where you can register with the police, provide them with that evidence, and then you are free from prosecution for cannabis offences. You can nominate two people who are your carers. They are also free from prosecution of possession and supply offences. So pretty limited, but it's a genuine thing. There's not many people on the scheme, but it is a genuine thing. It is not a trick. The police do not come and search you. They do not come and go through your backyard to see if you're growing a plant or not. It's a genuine... Sorry about the feedback in here. It's a genuine scheme, but you've got to be dying. The other scheme, more broad, is a scheme that's been in New South Wales for quite a few years, a cautioning scheme. If you are in possession of less than 15 grams of cannabis, you are eligible, police discretion, eligible to get a caution rather than be taken to court. So that's for whatever reason. You're going to smoke it for fun, use it because it's medicine, whatever. It does not apply to oils and tinctures. It does not apply to other products like hash and so on. It just applies to weed in its normal state. And there's only two, you only get two, and then you've got to go to court, so it's a bit limited, and it is up to police discretion. If you've got prior convictions and so on, then you don't get the caution. But that's useful for many, many people who are having one brush with the law on a small scale. Many, many people in that situation would be given the benefit of a caution. Pardon me. Other topic to talk about is driving. Probably everyone in the room is very aware and very conscious of the, not so new, but laws that have been around for about 10 years or so now that allow the police to randomly test, that is without any particular excuse, test people for drugs in their system if they are driving a car. But not like the drink driving rules that have been in place for quite some time, the power to stop and require a test is random, meaning that they don't have to have any particular reason. As you'd be aware, there's police setups around the place from time to time. Every highway patrol now has the equipment. They can do so. Single officers can now apply the test. The standard arrangement is they do a breath test first for alcohol, then they might or might not do a test for a saliva test for the presence of drugs. They test now for 4 drugs: cannabis, THC strictly speaking, ecstasy, methamphetamine and cocaine. The number of people who are found guilty, charged with that offence, going before the courts has increased astronomically in the last few years. It's now one of the second or third highest numbers. Sorry, put that the other way around. Of all the cases that go before local courts in New South Wales, it's third or fourth, second or third on the list of most frequently charged offence. Local courts do most of the criminal law work for in the court system, and it's a big proportion of what happens in court, particularly in the Lismore local court, I might say. That offence is to drive with the presence of THC. Let's talk about THC. Same for the other drugs as well, but let's just think about cannabis today. If the test comes back from the lab showing the presence of THC in your saliva sample, you go to court. It is not an excuse to say, I'm using cannabis for medicinal reasons, Your Honour. That is not a defence. It might be an excuse in terms of punishment and in terms of leniency, but it's not a defence to mean you are not guilty. The court has the power to use a provision called Section 10, good old Section 10, which is where people are found guilty of an offence, but because of circumstances, their good record, etc., the court does not impose a conviction. So you're guilty but not convicted under Section 10. The consequence of being dealt with under Section 10 is you don't get a fine, that's probably not that much importance, but you keep your licence. If you are convicted, you must be disqualified. There's a mandatory 3-month disqualification period of driver's licence, mandatory 3 months on conviction. So typically, in these literally thousands of cases that are coming before the courts, typically the person comes to court and says something like, I've got a good driving record, look, I've been driving for X number of years, this is my first or maybe second offence in all that time. At the time I was stopped, I was not affected by the drug. That is, I'd had a smoke the day before or 2 days before, whatever it was. There's a residue found in my saliva, okay, accept that, but there was no impairment effect. And the way these cases are put together by the police, there's never any evidence of impairment, so the magistrate says, yep, okay, accept that. And for many people, then the magistrate says, okay, Section 10, no conviction recorded, you keep your licence, sometimes with a bond. The difficulty is it's not a get out of jail free card for everybody, and secondly, you only get once. You can only have that provision applied once in 5 years. So if you get stopped again and are positive again within that 5-year period, you must be convicted on the second time around. Because I'm not talking very quickly, covering a lot of this stuff quite quickly, but because the offence only involves the two things. One being a driver, unless it's your twin, you probably are the driver. Secondly, the presence of THC in your saliva. So there's no cut-off level, really. There's no kind of indication about whether it's a lot or a little bit. There's no indication about whether you'd had a smoke 5 minutes before you were stopped or 3 days before you were stopped. It's just a presence reported by the lab in Sydney. Most people, therefore, have got no real choice to say, well, yep, I'm guilty of that. I don't have any excuse that's a legal excuse. I'll come back to that in a couple of seconds. So most people are in a position of saying, I have to plead guilty. If you've got a bit of a driving record, then you may not get a Section 10, even though it's a first offence of this sort. If you've had a Section 10 for, say, a low-range street drive a couple of years ago, common enough offence, then you won't get it for this on this charge this time round. So it's certainly a major problem, especially for those of us, like probably most people in this room, who live in the bush and don't have any real option as far as public transport is concerned. The only defence, in a sense, getting a bit loyally for a moment, there is a defence called honest and reasonable mistake of fact. So if you convince the court that you honestly, that is truthfully, believed that you did not have the drug in your system, and, here's the hard part, and that you had a reasonable basis for thinking you did not have drugs in your system, then you are not guilty, if the court accepts that. So the first part is the honesty part. You can't just, well, magistrate has to believe you rather than think you're just telling a series of fibs to keep your licence. The second part of reasonableness depends on what you knew at the time you were driving. There is some information which is not correct, but nonetheless it's the information that the government gives out on a website called the Centre for Road Safety, part of the New South Wales Department of Transport. I recommend that everybody, if you don't remember much about today, remember this. Have a look on Google at the Centre for Road Safety. There's a couple of pages in there. There's a page or two about random drug testing, and in that it says that the typical cannabis user will show positive under this test for up to 12 hours after consumption. That's not true. I've personally had dozens and dozens of clients who said, no, it was 2-3 days. Anyway, the courts hear that all the time, 2 or 3 days ago, 2 or 3 days ago. So it's certainly the case that magistrates are aware that the testing picks up more than 12 hours, much more than 12 hours really. The legal point is, if you rely on that information, if you read the website before you stop by police, it's got to be before, if you read that website before you stop by the police, and you read what the government tells you about how this works, it says 12 hours. If you rely on that, that has got to be, in my view, a reasonable excuse for believing that you would personally be not have any THC in your system. Leave aside the legality about whether there should be or shouldn't be under the law using cannabis. For this particular offence, if you have a reasonable excuse for believing that you would not have THC in your system, that is an issue of fact, not an issue of law, an issue of fact. Are you positive or not positive in terms of a physical presence of a drug in your saliva? And again, as long as the magistrate believes you're not just making that up, that you really did look at that website, then you can take the case to a hearing, contest it, and have at least some prospect of success of having the charge thrown out. I've run a number of cases successfully and a couple unsuccessfully, but nonetheless, it's certainly a possibility. But that's probably for a minority of people in a way. I saw a few people reaching for notebooks and so on a moment ago. The Centre for Road Safety is the name of that website, New South Wales, and it's reasonably easy to find your way around that website. It's got a couple of tabs at the top, and you'll find it easy enough. But the Centre for Road Safety, and the more people that I think use that defence, the better the world will be in terms of getting off. But otherwise, it's a very harsh law, and as I say, it doesn't really matter whether you are affected or not affected, or if there's any evidence of being affected at the time you're stopped. It's going to be a problem. And just to be absolutely clear, it is not a defence under that law to be a medicinal user of cannabis. It doesn't matter why. It's just if you have THC in your system and you're driving a car, in your saliva, and you're driving a car, then you are guilty. Probably. Harsh. That's probably all, I think. I think that's my rave. Happy to have lots of questions about that topic or any other topic. Should you say on that subject, though, all the announcements about medicinal cannabis and whatever the future might hold for medicinal cannabis law, which is very, very likely to be more liberal and more generous than it is right now, it's got to go that way. I mean, history is history, and it's got to go in a particular direction. But all the announcements from government about when we change the laws a bit more, all those announcements are we will not change the driving laws. So there is no prospect of any defence being introduced under that driving rule. I know it affects and concerns quite a lot of people. Anyway, I might leave it there. Questions for the next, until Michael says I've talked too much. And if people could just grab microphones to ask the question. I'm going to be randomly seeing whose hands go up first. I think the woman in the back at the front was pretty much the quickest.
I'm going to get on my around, but I get the first question. Right.
That's fair.
Yes. And it's just two quick questions. Number one, let's say I'm just taking CBD oil, hemp, and it does have trace THC in it, we know that, but I don't take cannabis at all, I do not take THC. Is that a reasonable defence? Number two question, is there any lawyer that is actually striving to change the humanitarian rights in terms of the law of cannabis in Australia?
Two good questions. I think you mean, Sister, the driving law?
Yes.
About the CBD?
The state of cannabis.
CBD, yeah. So the driving law, the way the law is written is the presence of THC in your saliva. It's not described in the law as presence of cannabis. So CBD, probably many people, maybe everyone in this room is probably going to learn a lot during the day, but I'm assuming at this stage that people know there is a difference between CBD and THC. The CBD bit doesn't get you stoned, the THC bit does. So if you had an honest belief, and we've had a couple of cases, I haven't run them myself, a couple of cases where a person thought they were using a medicinal product that was only CBD, and you relied on that information, in my view that would be a reasonable excuse on your part to think that you did not have THC in your system. We've got a client we're dealing with at the moment that's only got early stages, so we'll see how we go with the argument. But this particular fellow had an analysis of his product which said CBD, 0 THC. So you would have thought, it's a pretty good argument to show to the judge, look, this is what he thought was in the thing. My understanding is limited, but it's also this, that a lot of things that are presented as CBD-only products do contain some THC. It's difficult, as I understand the process, to produce a medicinal oil that, for CBD, for example, that has 0 THC. So might not have very much, but it certainly is a possibility that you might be using a CBD product thinking that it's just CBD, but it might have enough THC in it that you will still test positive because the test the police apply is absolutely ridiculously overly sensitive, picks up all very, very minor traces of THC. So it's possible. So on one hand, just using a product and not thinking about it, just thinking, oh, I'm going to use this because it works, and not turning your mind to whether there's THC in that product or not, would not be reasonable. You know, that again sounds harsh. That's not my view. That's the court's interpretation. It's not just about common sense. It's not just about, oh, I thought I'd be right. You've got to have active steps to think about what you're doing and why you're doing it, and to have a reasonable basis for thinking that you are not breaking the law, not putting yourself in a factual situation that would be against the law. On the human rights issue, short answer, no. Australia's legal system has very, very little about human rights in it. It's not quite as terrible as it first sounds when you put it that way, but there is certainly no Charter of Rights, there's certainly no legislation or constitutional arrangement that sets out rights in a strong way in our system. In many cases, courts will sort of twist and turn and try to find a way in which some rights can be found, and certainly the High Court's done that over the years and sort of created some rights that don't appear in the words of the Constitution. But there is no right as such to use cannabis, of course. There are human rights, they call them instruments, treaties and so on, through the United Nations and various other international forums and so on. Lots of them, dozens of them, hundreds of them, that Australia signs up to. Australia being a signatory to the Declaration of Human Rights, for example, or the International Covenant of Civil and Political Rights, whatever that one's really called. We sign them all. Just a good citizen, aren't we? Good international citizen, Australia. We sign them up for all, but then we don't do anything about it. We sign our name. That's all we do. So they don't actually become part of domestic law. It's not law. The fact that the Declaration of Human Rights exists is a thing. Australia has signed up to say we support it. Does not mean that the provisions of that declaration apply in court in Australia. Yes.
Thank you. Two questions. One reflects what you said.
Sure.
So the onus is on the user. I'm using medicinal cannabis in the form of CBD and then THC. But with the CBD, you just mentioned there could be traces of THC and that could potentially come up in a road test. So the onus is really on the user to make, you can't go, oh, I didn't realise this is THC and it says CBD, that's all I thought it was. That doesn't work. The onus is on us to verify that there's absolutely no THC in there. Is that right? That's my first question.
Can I answer that one first? Because that's a kind of good question with a long answer, if you want to hang on to the second one. The word reasonable is one of those lovely words. Lawyers love it. People who write laws love it. It appears in all sorts of legislation. The point of the word reasonable appearing, anywhere you see it in law, is a very deliberate purpose, and that is to allow a court to determine case by case what is reasonable. Okay? So rather than a law that says, between here and here this behaviour is wrong, it says, well, behaviour like this is, if it's unreasonable, is wrong, put it that way. So the reasonable excuse part of it has to be, in terms of the driving law we're talking about, the reasonable excuse part of it has to be more than just turning a blind eye, not thinking about it, forgetting, not thinking about it. That's not considered reasonable. You have to make some, as I said a moment ago, some active steps. So if you have a product that your dealer, if I can use that word, says it's CBD, here's your CBD, and that's all you do, that is you take it, thanks very much, grab it from the person giving it to you and use the product, then in my view, that would fall short of being a reasonable, meeting the standard of reasonableness in the court. The magistrate decides case by case. So it would depend exactly on what you did, what you thought, what you knew, and how honest you were about that belief. I think the best way to explain that in a sense is, in a comparison, drink driving has been around drink driving has been around since there's been cars, of course. Drinking was before cars, but then they had cars ready for drink and drive as well. But when they brought in the random testing, 30, 40 years ago, it's a long time ago, isn't it, with the low range in particular, they used to have ads on TV that says you'd have one beer in the first hour and then after that. Remember those ads a few years ago? They stopped that advertising because it was misleading. People were still having one beer and then driving home from the pub and being found in the low, particularly in the low range. So that law has been around for quite some time. People who think, I've just had one beer, I'm going to be fine, that has never been considered a reasonable excuse. Might be honestly held, but not a reasonable excuse if you have a beer, drive a car, you think, I can't be right. Because that's just applying your own common sense. That's not really applying any kind of independent or objective standard to the decision making. You just think, one beer, I'll be fine. Which is why they stopped the advertising, so you can't say this. You said on TV, it's okay. And it's just not sufficient. So in a similar way, people who think, I'm using a CBD oil and that's all they think, full stop, that one thought or half thought is, in my view, not sufficient to be considered reasonable.
And that sort of segues into my second question, which is airports. So I travel and I now need to take I'll leave my THC at home, but I need to take my CBD with me. And there are dogs now, more and more, and so they can't distinguish, I'm sure, between CBD and THC. So what if the CBD is...
You're going to be treated as if you're a cultivator for profit. No jail, good behaviour bond, safe enough, a bit of drama, but safe enough in terms of jail time.
What about 2, 3?
2 or 3, first offence are fine. Section 10. If you're 2 or 3 plants using it medicinally, again, if the magistrate accepts that, then more chance of a Section 10 for a first offence. The restriction I said about Section 10 only being used once in 5 years only applies to the driving laws, so not to other laws, by the way. So if you're a serial offender in terms of a cultivation, there's no absolute prohibition on being able to have another Section 10, but most magistrates won't give another one within a short time. You have to have a pretty good argument about it. So a small number of plants, first offence, fine, or no conviction recorded. Defences include all sorts of things. I didn't know was there. There might be an argument that you're not guilty of the offence, but if you're pleading guilty and the number is reasonably small, if it's consistent with personal use, then you're going to get off reasonably leniently. Good time to say this. The offence of supply, again, definitions in the New South Wales Act, includes not just selling a drug, but giving it away, sharing it, passing a joint, strictly speaking, is a supply of cannabis. So if you're growing plants and you're going to share it with your friends, that is not the best thing to say to the police because you are making admissions about intention to supply, just by the way. Wouldn't have just been an occasion. A bit louder, please. Thank you. It's okay.
When it runs out, and I order more online and bring it in legally, or is it
I know this gets confusing and confusinger. The importation laws are federal laws, not state laws. The federal, what used to be called the Customs Act, but it's called something else these days, has provisions about importation of what they call, not prohibited drugs, controlled drugs. And in the definition of controlled drugs, cannabis appears. Not THC, cannabis. CBD is cannabis. So it would depend on the quantity of the sort of percentage. If it was permitted by the TGA, as in it's allowed, then it would be lawful. Many hemp products, because they have such small quantities of THC in them, are officially allowed. So probably something imported from overseas with described as CBD, a CBD cosmetic of some sort, probably would be legal, and you'd probably be entitled to assume it's legal if you buy it off at a shop and on a counter. It's just there for sale. And again, that comes up fairly often, that people went to a shop and bought it. I didn't know it was illegal. How could it be illegal? They sold it to me. Anyway, so probably, but in terms of strict definitions, the fact that it's CBD is not itself does not itself put it outside the import laws, the customs laws for it to be not cannabis, because it's just defined as cannabis without breaking down CBD or THC or any other, 350 ingredients, cannabinoids that appear in cannabis. Hey.
I was just wondering too, with growing it, if you could prove that you were growing it to make your own, say, CBD oil, even though it's illegal, but you were making it for a close friend or a family that ended up sick and chose not to go through chemotherapy, is there any chance that the judge would be more lenient on you?
There's every chance. Just by the way, I'm assuming people can hear everybody with the microphone. It sounds pretty okay from up here, but I'm up here. Yes, it should be okay. Depends on the magistrate. There are some are better than others, I'm prepared to say in public. But one of the real problems is that it's humans. Humans is the problem. Humans administer the laws, and magistrates are different people, and some of them are more conservative than others. But also humans are the people who come before the court as defendants. I have not heard anybody charged with the possession of cannabis in the last 10 years say to the court, yes, I was in possession of that, who doesn't also then say, I use it medicinally. I've got a bad back, I've got this, I've got stress, I use it for medicinal reasons. Everybody thinks that if they say that, then they're going to get leniency. Because everybody says that. That's what magistrates hear literally all day, every day. They're common charges, everybody uses it medicinally. Apparently no one smokes pot anymore for fun. I used to think it's given up. Or the policing is just so extraordinarily inefficient. They only pick up people who use it medicinally and not everybody else. How does that work? And anyway, so the difficulty is humans being self-interested, selfish people, present company included, will always look for that out, always look for that excuse, and the magistrates hear it all the time. So if you've got something to support that, it helps. A lot of people go to court on possession charges, hand up a note from their doctor that says, this person says he's got stress and he uses cannabis. I don't know, that's what he tells me. Almost no weight is put on that, okay? If you've got a sick person who has got a serious condition, a cancer for example, you provide a medical report about your mum. I'm going for my mum, Your Honour. She's got this really serious illness. Here's her doctor's report. There's only 3 or 4 plants. That's all it's going to do with it. Probably the magistrate would believe that and accept that and then apply what leniency they could. That might be a Section 10 if it's 3 or 4 plants. Might be.
Steve, hello.
I don't know if that's on.
I'm hearing all the time of how to make myself...
I think that's not on, that mic.
Find out, yeah, there we go. All the time I'm hearing how to make myself smaller and more invisible in my own society. You know, as a woman advancing in years, taking cannabis oil is the best. And a whole lot of people say the same. It makes old age more bearable, hey? It really does. And it's fantastic. And I look at what it does for me and so many people around me. So if I could be so bold as to see you as a conduit to the legal system of which you are a part. That is, I'm following up on that human rights angle put forward before. Our bodies are now invaded. We no longer have the rights to our own body. On the side of the road at any time, I've got a cop in a uniform saying, open your mouth and stick this in it, and you're going to keep it there until I say you can take it out. End of story. Now, I understand that because I have a licence, I lose rights for everything else. As a legal system, can the legal system start to stand up and get sensible on the restriction and the vilification of a population to try and fit into some rules and laws that just are not possible to fit in unless you don't use the stuff at all? So Steve, what's the chance of the legal system standing up as a voice for our people, for the community?
too. Look, I think all of us agree with the sentiment. My estimate of the chances is probably anybody else's estimate of the chances of the law changing. I think it will change. It's unsustainable, in my view, that prohibition will continue for much longer. But I've had that opinion for about 20 or 30 years and been wrong for a long time. Obviously, internationally, there's lots of movement. Half of the states in America now make cannabis legal, as in for any purpose. Well, some are for any purpose, some just for medicinal purposes. Canada, of course, just this week has brought in a rather elaborate legal system, probably a little bit not the ideal system, but nonetheless it's legal. Half of Europe, it's going to happen. New Zealand will beat us. My prediction is New Zealand will legalise cannabis in a few years. Australia will say, oh yeah, you could do that too. And then it'll sort of quietly become a change in the law. And those of us approaching old age, not there yet, might be able to enjoy a legal joint on our back veranda as the time passes away. But it's certainly not going to happen this year or next year. It's not going to happen, in my view, very soon. I think it's not an area where Australia is going to lead in any way. We're certainly well behind the leadership on the issue anyway. Now, we're not going to be close up behind the other leaders like the Americans and the Europeans. We'll be one of the last, but it will happen. I don't know when.
Then we got a question here.
Hi, my name's Pauline, and I was interested in going back to the cultivation with the Australian Cannabis University. Where do they stand?
The university. Some people, you can... Part of the changes they've made around medicinal cannabis over the last few years also allow for licences to be issued to people to grow cannabis. Cannabis is, of course, broadly speaking, for medicinal purposes, so for research purposes and so on. Before that, there were a few licences available for people to grow for industrial, so-called industrial purposes, that is very low THC cannabis. So there's a few people around here who have those licences. So it's growing cannabis itself, as an absolute statement, is not illegal if you have a licence to do it. You can get a licence if you're going to grow for fibre, for to turn it into hempcrete or something, or if you're going to use it for a medicinal product. If you go through this very elaborate process to get a licence to produce a medicinal product, you can grow. Part of the ridiculousness of it is you can get a licence to grow cannabis for medicinal purposes. You can get a licence to manufacture a medicinal product, but you can't have both. So you can't get a licence to grow and turn it into an oil. You can only get a licence to grow if you have a manufacturer lined up who will take your product, your weed, and turn it into an oil. You can only get a licence to turn it into an oil if you've got an arrangement, a contract with somebody who's going to grow the stuff for you. Really. Who thought of this? They think this is what they call reform. All these politicians who stood up proudly and hand on their heart, we've reformed the cannabis laws, we're doing all this thing out of compassion for sick people. We know the law has to change, and that's the law they brought in, really.
Thank you.
Chibo's in charge, I think he's got the mic up.
I'm sorry I didn't talk the tail end of your presentation. I've come to the question at the moment that the presumption that the rights are gone and not, they're intact. One just has to know how to exercise access to them. And use of cannabis is not unlawful. It is maybe illegal. Two different things. My question is, have you used the non-consent process during proceedings?
Unlawful, illegal are the same things. The consent process I think you're hinting at in your question comes from a body of understanding about common law. Am I right, my friend? No? In any event, there's no consent. Consent is not part of the legal system. You do not have to consent to the law applying to you. The law applies to you. If the Parliament of New South Wales passes a law that says it's illegal to consume cannabis, then that's a law. The Constitution, New South Wales has a constitution, very, very limited constitution. the Constitution of New South Wales allows the Parliament to pass laws for the peace, order and good government of New South Wales. 1850-something, the English law, when they created the colonial parliament way back when. So, wide open. Anything the Parliament wants to do is pretty much for peace, order and good government. Whether we agree or don't agree with any particular law, it's a law that passes that very easy test. So, whether we consent or don't consent to the law doesn't matter at all.
We got a few last questions over here.
Yeah, I just wanted to ask, recently I had a friend who was in Amsterdam and bought a vial of CBD oil with 10% of the THC. It was bought back from me to you, and I wanted to ask you what the legal implications were for that. We managed to get one through, but I was really cracking myself thinking that, she was going to get done, or, could we be done in customs? And also, what are your thoughts on the fact that you can buy it overseas, have it bought in here? Are you at risk of prosecution?
Look, I think it's a similar question to the question answered before about the CBD cosmetics. It might, whatever happens in other countries, if you go to California, a similar example to yours, you go to California, smoke a joint, buy some weed because you can legally buy it in Los Angeles, great. Hop on a plane, come to Australia, you're no longer in California. So the laws that apply here are the laws that apply here. The customs law allows if they detect it, whether it was legally obtained in another country is by the way. If it's not lawful to bring it into Australia, okay, without a licence, and that's the case in lots of other situations as well. There's a few the reverse effect where things are legal in Australia, but you can't go when you take them overseas. They're not, not as much. Not cannabis, of course, but there's other things that are lawful here, but not lawful in other countries. You get stopped at the border and you're giving an offence, maybe. If you bought a product lawfully overseas, stopped at customs might seize it and not charge you with it because they just think, oh, well, that's fair enough, a mistake, you made no trouble at all, let you go. But you might have to go to court, and then you might have to argue in court that you thought it was okay. Again, it'd be likely to be that honest and reasonable mistake. You honestly thought it was okay. Was that reasonable? Did you turn your mind to the differences between the law of Amsterdam and the law of Sydney? Maybe you didn't enough, and so maybe not a defence. Okay?
Yeah. I've got a question about cannabidiolic acid.
Oh, there you are. Hear the noise.
Yeah, okay. Cannabidiolic acid. Is there any place in the world where it is legal?
Sorry, what was the first part?
Cannabidiolic acid. Is it legal in any part of any country in the world?
What's the question? Put it another way around. What is legal?
All right. Are you allowed to eat fresh hair? That's where, yes.
Yes.
Okay, so is there places where you're allowed to grow it and eat it?
Yes.
Where?
Yes. Half the world these days. Half of the United States, Canada, Portugal, Spain, Africa, most places really. It's only in Australia, in New South Wales, there's state laws. In New South Wales, every other state too. In New South Wales, it's an offence to consume cannabis, to smoke it, to eat it. Doesn't matter how you eat it in raw, eat it in cookie. That's the offence. To possess it is an offence. So possess it in raw, green, vegetable matter material form, little plastic bag of something, or in a cookie or whatever. So the form of it doesn't matter, as in, is it raw, is it cooked into something, is it rolled up into a cigarette, doesn't really matter. If it's cannabis, it's cannabis. The law requires this is an odd thing, I know, the weight, it all depends on the weight. So if you're in possession of cookies, they weigh the cookies and it's 5 kilos for goodness sake, but it's mostly chocolate and flour and whatever with a little bit of cannabis. So usually that's resolved on a sensible basis of it's 4 cookies, right? Not really 5 kilograms of cannabis, it's 5 cookies. Okay, dealt with it as a small quantity. Okay, but yes, it is legal. Wherever it's legal to grow cannabis and possess cannabis, it's legal to eat it. Doesn't matter how you consume it, it's legal to eat it.
Steve, we should wind up. Last question.
One more question, I think. we've got medical people to talk to. Just by the way, I'm going to be around at least till lunchtime. Happy to have private conversations with people about. This is obviously not the place to talk about anyone's particular personal circumstances, but I'm happy to talk about either general questions or more particular questions. You'll find me outside drinking coffee, I expect, for the next hour or two.
Sorry, just one quick question. Is Section 10 a New South Wales thing?
Yes.
So it doesn't apply to Queensland? Because I've come from Queensland.
It's Section 10 is the provision in New South Wales. Every other state has the same provision. It's not always Section 10, but every other state has the same provision. It's yes. It's Section. What's the Queensland provision? Section. I can't remember now. But it's a different legislation, but the same effect. That is, all courts have the capacity for leniency. It goes back to that sense of mercy, the sort of broad philosophical point about the Crown being able to be merciful when people have committed an offence. It's now translated into a statutory arrangement, a legislative arrangement, Section 10. All the circumstances, usually good character, little or no prior record, and a fairly minor trivial offence are the usual ingredients in New South Wales and other states. So the combination of those two or three things.
Okay, we finished now, and everyone can immigrate to South Africa, where it's my grandmother's my grandmother in the background. Legal.
I couldn't hear that. Could you all hear clearly, Steve? Good on you. Hey, thanks heaps, Steve, for coming. On his Saturday, he would have been sailing or something.
It's all the same. It's legal in South Africa, recreational.
I know. Clever. I've got a couple of bookkeeping things to tell you. The toilets are just through there. I think men's toilets are around, but they're at the back there. Anyone... We'll have a break at about 1 o'clock. Andrew Catalaris is going to talk now, and then we'll have a break for probably about an hour. There'll be demonstrations outside of how to extract the essence out of the